So it's come to our attention that some attorneys, they advise some companies to refer their cases, the job cases, to the High Court and not to the CCMA. So what is the jurisdiction on that, Skalk?
Yeah, I sometimes sit with a smile when I see all the money-making schemes that popped out because of COVID. Yes, not only employers, as you stated, employees also. You will find unethical lawyers of all types and consultants of all types telling employees and employers that they should disregard the CCMA, they should disregard the Labour Court, and they should take cases to the High Court. Now, why on earth would you do that? When you read the Constitution and you read the legislation relating to the labour regime in South Africa, in other words, the body of legislation in South Africa, you will find out very soon and very easily that jurisdiction in labour cases preside in, number one, the CCMA, the Commission for Conciliation, Mediation and Arbitration, the bargaining councils accredited by the CCMA, and the Labour Court. The Labour Court is a specialist High Court dealing with labour cases. Why on earth would an attorney advise an employee to bring an urgent application to High Court, ordinary High Court, an urgent application to High Court in a labour-related matter, and disregard the legal channels that is there by law? A creature of statute like the CCMA that is there by law to adjudicate your matter. There's only one reason I can think why an unethical attorney would do such a thing. It's just simply to skim money off of the client.
And lots of it.
Remember, we're speaking High Court litigation, so we're speaking of tens of thousands of rands that will be spent. Let's deal with the issue of urgent applications before a High Court. Any court, including the High Courts of South Africa, has a case roll where you go and enroll your case. You must remember that there are hundreds of cases that are enrolled. A case gets a case number and it gets a date and a time and a judge before which the case must be brought. Now what happens? If you want to take a case on an urgent basis to court, you now disrupt this whole system. You must go to the registrar of that court, and you must now convince that registrar to put this case before a judge at a time and a date that was never discussed and never agreed upon between any parties, and to the detriment of those parties who are waiting already for months to be heard before that judge. Now, if you actually get the registrar so far as to put your case on the roll, then you face a judge, and you must then convince that judge to hear the case on an urgent basis. Your case is not there automatically to be heard. So it's actually a double application that happens. The first application being convincing the judge to hear the case. And in most cases, especially labour-related cases, the judge will simply not hear it because he will tell you there's a system in place already through the CCMA in which your case can be handled within 30 days of referral through conciliation and within 90 days through arbitration. Why on earth would you now run to CCMA on an urgent basis? So the chances,
to the court.
To the High Court on an urgent basis. I can promise you the chances of you getting heard on an urgent basis before a High Court on a labour matter is virtually zero. We are dealing with cases of extreme urgency that will be heard on an urgent basis by a High Court. The Labour Court itself is also not a court of first instance. In other words, you do not go first to the Labour Court and then to something else. Usually a case is heard before the CCMA, an award is made, The award can be then taken on review, not appeal, review to the Labour Court. But the Labour Court indeed does have jurisdiction very clearly defined in law where they may hear the case afresh. In other words, you bring it to the Labour Court. Even in the Labour Court, you're going to struggle to get a Labour Court judge to grant you an urgent application. Why? Because the system has been crystallized to such an extent that it does not need to have any urgency in itself. A very urgent case, for instance, would be where an employer sits with a workforce that all of a sudden decides to down tools and they go on an illegal strike, and that causes a business to face closure. That would be an urgent case where the employer will then go to the Labour Court as quickly as possible and ask for an interdict. That is one of the instances I can think about. For a person relating to COVID, we're now in year 2, nearly year 3 of COVID, to now run to a high court, whether that be the ordinary court or the Labour Court, on an urgent basis, now trying to convince the court to listen to you in such a way. It's simple folly. You will not be able to do that. And then, of course, if you are indeed, for some reason, successful, now the main application must be heard, and usually an application like this that is so intricate will not be heard on that day. It will be postponed in any event until such time as the other side could prepare themselves for that case. So what am I actually saying to you? I'm saying to you, if you run across the path of a lawyer, being an advocate or an attorney, but these are usually the attorneys, I've not heard it from advocates, and that attorney tells you, you must now give me 40, 60, 80,000, 100,000 rand, what in my trust account, so that we can urgently take your case to High Court. He is BSing you, he's stealing your money.
Think twice.
He knows exactly, or she knows exactly, that the case will not succeed, and you will sit there having paid for 2 applications before court, not successful, and then being told a little nice story of it's the court mistake. It's not anybody else's mistake. It's that judge's mistake. He made a mistake.
Yeah.
But now we're sitting with a problem, and we must enroll the case on the ordinary case roll of that court. Don't be fooled and caught out by these unethical attorneys. They are out there. If that happens to you, please contact skalkvandermerwe.com. I want to report those people to the LPC.
Oh, yes.
And I want them to be disbarred, taken off the roll of attorneys, because it's unethical.
Definitely.
To give advice like that to clients.
But hey, if you have money to waste, well, go ahead. But yeah, we don't recommend that.
No, definitely not. As I say, please contact me, skalkvandermerwe.com. Don't go and look for my cell phone number. It's still in use, my business number. Don't go and look for email addresses. You simply Google or whatever search engine you use, skalkvandermerwe.com. You will get my website, and you will have ample opportunity, a lot of prompts there that you simply prompt and you send the message to me.
It's very user friendly.
It's as simple as that.
Yeah.
Thank you, guys.
All right.
I think that sums it up.
Yes. Thank you.